So let me ask a question to get started. How many of you here have heard of Coin Center before this? Whoa, that's awesome. That is much more than I was anticipating, so thank you. So look, my name is Jerry Brito. I'm the Executive Director of Coin Center. This is Peter Van Valkenburgh. He is the Director of Research at Coin Center. And we thought we were out here in San Francisco this week for a bunch of meetings and just hanging out with folks, and we thought, let's talk to the devs, the people who are actually building the thing that we see ourselves as defending in DC, and tell you about who we are and what we do. So we're going to have a short presentation where we're going to tell you, who we are, what we do, and we're going to give you kind of our policy roadmap for the next 6 to 9 months so you know what we're working on, and then just take your questions. So what is Coin Center? Coin Center is an independent nonprofit based in Washington, D.C., and our mission is to make sure that the same benefit that the early internet had applies to open blockchain networks, right? The early internet flourished and really benefited from having a hands-off approach from government, and that to the extent that there had to be regulation related to the early internet, that it was very light touch. And that allowed the internet to flourish and prosper. We want to see the same thing for open blockchain networks like Bitcoin, Ethereum, Zcash, whatever it may be. And that's what we want to do. We essentially want to decentralize all the things. We think this is inevitable. You guys are going to build it. And when things are decentralized, right, it's very simple, very easy to regulate speech when you've got 3 broadcasters and 1 local newspaper. But when you have the web, it becomes difficult to control all of it. Not impossible, it becomes more difficult. And we think we need to decentralize all the things, including things that have to do with money, things that have to do with value transfer of all kinds, and that this is going to happen. The question for us is this going to happen in 5 years, in 10 years, in 50 years? And we want to make sure that it happens sooner rather than later. And that means making sure that government doesn't keep it from happening sooner rather than later. And the way we see it is we want to buy time for this technology, for all of you, to have this technology reach escape velocity as soon as possible. So, is that the next slide? Okay, we're a small team of 5 persons, 3 attorneys on staff. We're 5 full-time professionals focused only on open blockchain networks. We're based in DC. About half of our support comes from individuals, individuals like you who are independent and just care about this technology. The other half of our support comes from great supporters that are either investors or company in the space. And I see many of you here, so thank you. And it really spans the gamut from just about everybody in the sort of open blockchain network space. So what is it that we actually do? We do 3 things. We do education, we do policy research, and we do advocacy. Education is probably where we spend most of our time. That's changing a little bit now, but really over the past 2 years, and Coin Center is 2 years old. Education is where we spend most of our time. And what that means is making sure that folks in government, whether it's congressmen on the Hill or their staff, folks in agencies, folks at state legislatures, that they understand what this technology is, how it works, and if they have any questions, they have a place to go. Right? They want to pick up the phone and call Bitcoin to ask a question. There's no Bitcoin that they can call us. And if we can't answer the question, we can find one of you to help answer those questions. And we do that education through one-on-one briefings with folks in government, one-to-many briefings. We'll testify at hearings. But essentially, we will also publish backgrounders where we have sort of plain English explainers about discrete topics that explains the technology for a lay audience, for a policymaking audience. So that's really the education piece. As we have these conversations where we're answering questions for them, inevitably we get to a point where there are questions to which we don't have the answer. And it's typically because it's not a question about how technology works, it's a question about law or policy. And it's about a point where the technology has outpaced the law, right? Where you can now do things with the technology that the law didn't contemplate. And so there's a gap, there's a gray area. And regulators don't like those gray areas, and they're going to want to go fill those gaps, color in those gray areas. And so that's where we engage in our policy research, right? We develop the policy thinking that sort of looks at what are the different alternatives that government could consider to fill in those gaps. And then we choose and we advocate for the alternative that helps a regulator meet their policy end, because look, whether we help them or not, they're going to find a way to fill that gap. But we help to point them to the policy alternative that's going to preserve the freedom to innovate, to do the least damage. And so that's the last thing we do is advocacy. We advocate for our preferred policy positions. We lobby for those positions. So that's what we do. So again, we publish backgrounders. We could use your help writing a lot of these backgrounders. I know some of you here have written some of these for us before. So backgrounders. We publish reports, which basically, these are the most basic form of our policy thinking with our policy prescriptions, right? So we've got them on securities and regulation. We've got them on overcoming obstacles to banking for virtual currency businesses, which is a big issue. We've got money transmission, which we'll talk about all these things in a minute. We file regulatory filings with different agencies, both in the US and internationally, although we're more US focused. We will testify. We've testified in Congress, in different state legislatures. We'll do briefings. We'll have all kinds of different outreach to government. And an important thing to note about us is, again, we are focused on open blockchain networks. And Bitcoin really, folks in Bitcoin were really the ones who got us off the ground. But the important thing to know is that any policy or law that affects one cryptocurrency or one sort of token-based decentralized network really will apply the same way to all of them. So this, what we do for Bitcoin, we're doing it for Ethereum, we're doing it for Zcash, we're doing it for any open network. So what I'm going to do now, Peter and I are going to do now, is sort of just dive sort of at a surface level a little bit into two of the policy issues that are top of mind for us right now. And again, as I say, what we're going to be sort of working on in the next 6 to 9 months. The first thing I'm going to talk about is money transmission, and then Peter's going to talk about securities laws. And so with money transmission, it's really odd for developers who are used to just, they want to build something, they hook up to the open permissionless internet, build it, launch it, run it, and it's working. It's hard to them to conceive that sometimes the government expects you to seek permission before you can tinker, innovate, and build. But that is the case. And that's especially the case when it comes to consumer protection. When you're doing something with money and not just speech, there are going to be consumer protection laws. In particular, the main consumer protection law is going to affect Bitcoin companies is going to be state money transmission laws. Right? And this is something that is state by state. There is no one regulator. If you're building a Bitcoin app that is custodial in nature, you're likely going to have to go get a license, permission to build it and to have customers from every state in which you're doing business. So that means 47 states and territories, right? There are 3 states that don't require.
Yeah, any state where you have customers, you have users.
You have to get this licensing. The issue is that each state is absolutely different. They're all developing these laws right now, and so they're unclear. And the important thing to note is that even if a state hasn't issued a bit license type law where they've addressed Bitcoin or cryptocurrencies, the existing money transmission law applies to you. This is important in California, for example.
May apply. Every one of these money transmission laws is drafted differently by the chaotic process of the state legislature, where they get really high caliber politicians in the assemblies. Every statute is different, and trying to figure out whether Bitcoin qualifies as money under their definition of money is one question. Then trying to figure out whether using Bitcoin in some way, holding it for someone else, qualifies as money transmission under that definition qualifies is a different process in every one of the 47 states and territories that have these licensing laws.
Right. And do we?
Yes.
So our vision is global in scope, but we know we can only do one thing right first. And given our limited resources, we're focused on the US. From time to time, we will venture out globally, but also from a security standpoint, Peter's going to talk about, really the US is where we need to pay attention to.
And actually money transmission as well. Both the two hot button issues that we're going to try and go through today, money transmission and securities, the US is the worst of the pack as far as being friendly towards permissionless innovation, because the securities laws apply significantly more broadly. They're not listed in enumerated statutes. And the money transmission laws are done state by state. So in the European Union, for example, if you get an e-money license, you can take that and passport it through all the different states. Brexit's going to screw that up a little if you had a UK e-money license, but generally we're looking at a more rational regime.
So the issue is, you've got these individual state laws, and today, states are slowly, New York BIT license was the first. The states, little by little, are looking at their money transmission law, and they're either saying, how do we apply our existing law to Bitcoin and other cryptocurrencies? Or how do we develop a new law, like the BIT license, for digital currencies? And so as they're doing that, we're in each of those states. And we have a few goals. Elizabeth, do you have a question?
Good question. So the first draft of the BIT license came out in December 2014, and we thought at the time we could see a lot of states go through their own versions, but we haven't. So what has changed with that 2-year period around the policy in money transmission in the US?
So I think, so the question is, why haven't we seen more states? So number one, I do think we've seen quite a few states, but you're right, not the avalanche that we were expecting. I think a couple things have changed. One is there was a lot of blowback to New York, and I think regulators sort of fiasco. But I think a lot of regulators saw the blowback to New York, and New York didn't get it quite right, and they wanted to wait and see a little bit. The other thing is that New York was kind of a special case because there's such a big, powerful regulator, right? New York being the financial center of the world, where the Delaware or Texas regulator might not be as quick. And then finally, we've been working, and this is something I'm going to get to, with the Uniform Law Commission to develop a model act. And I think when states began to see that the Uniform Law Commission was developing a model act, they said, well, we'll wait for that. Okay? But I'm going to get to that.
I think also Mt. Gox factored prominently there. So the BIT license process was actually sped up because of Mt. Gox. At least that's what we hear from Dana Syracuse, who used to work there. And we haven't seen a hack nearly as large, although Bitfinex is an interesting situation. And I think that took some of the wind out of the sails of regulators who are trying to look at this question.
Right. So when we're looking at this, there's a question over there.
Just so we can be clear for the rest of the talk.
Yeah.
What does custody mean?
Okay, so this is the point. This is what the slide is about. So the way we see it, right, when you're thinking about a policy level, we're not talking about law here, we're not writing the law yet, we're just thinking about a policy level. At a policy level, what we need to get policymakers to agree to is that you only present a risk to consumers if you hold custody of consumer funds. If you don't hold custody of consumer funds, you should never be regulated. If you do, then it's reasonable to expect that the government is going to require a license from you. The problem is that the way that the laws are written today, custody, the way custody is defined, they weren't thinking of things like lightning nodes. So it's up to the interpretation of the regulator whether they're going to apply it or not. So we want to have a clear distinction. Do you want to talk about what custody is?
Sure. I mean, custody is not even defined in most of these money transmission statutes. Money transmission as an activity is defined often by defining it as the transmission of money. Sometimes as receiving money for transmission and transmitting it, which is actually better for something like the Lightning Network or for any off-chain payment channel or things like that, because it's hard to argue that you've actually received something if you can't walk away with it, I think. And so if you have a 2 of 2 multisig and an n-lock, have you really ever received anything? That's an argument we may have to make one day. But ideally we wouldn't, because ideally the act of money transmission would be defined as a custodial act, or an act where there is true and full control over the funds in question. And then you would have a definition of what control means in the context of digital currencies. And that definition that we propose is basically, it is the ability to unilaterally execute or indefinitely prevent a transaction with somebody else's money. So that is an attempt, and I think a pretty good one, certainly better than leaving these things undefined, to address things like multi-sig transactions where there is no unilateral ability to transact unless you have sufficient keys in a multi-sig, and where in an n-lock type situation, you do not have the ability to indefinitely prevent the user from transacting with the funds. There is probably just some sort of time lock.
What about, though, in situations where regulators are concerned about financial crimes, where even if you can't walk away with funds, you could be, an accessory?
Right, so state money transmission licensing, the core policy that underlies those laws is a desire to protect consumers from losses. So it's Western Union failing to remit your money to the destination and you being left holding the bag.
So we're
It's
talking,
not-
so,
Yeah.
oh, well, oops.
Money,
Yeah,
money,
so-
money transmission laws also deal on the federal level, and these aren't even money transmission laws, these are money services business regulations under the Bank Secrecy Act with anti-money laundering, which we should all really just start calling financial surveillance because that's really what it is.
Yeah.
So is custody the same as control? Like when the Ethereum developers rewind the chain, is that the same thing as custody in this definition? I'm trying to understand your guys' perspective.
Like a block reorganization.
No, a conservative block. Something that's organized, not something that's a function of the.
So the question is who has control and is it unilateral?
Yeah.
I mean, Vitalik does not have unilateral control to reorganize the block. No, he doesn't. He has the power of persuasion, and he's sometimes very persuasive, certainly amongst his community, but it's not a unilateral ability to actually move away with someone's funds.
And to be honest, the state consumer protection regulators are looking at this.
Not even
They're not
close to
looking to regulate the Ethereum ecosystem. We're focused on what we're focused on. So given that, as you point out, these states, one by one, are trying to figure out what custody is. And we have our proposed definition of what custody is. And our goals is very simple. Is number one, making sure that that definition gets accepted into law so that we can exclude everybody who should never be regulated. And so the only folks who ever be regulated are the ones who are custodial. And then for those folks, we want to make sure that the requirements of the regulations are consistent and across the states, that they are going to be rational and they're going to be simple to comply. Right? So that's our goal. So how do we do that? Well, number one, we engage state by state. Right? So most recently, Washington State was developing a new money transmission law that was going to include digital currencies. We worked with them. They had some issues with control where their definition would have potentially covered multi-sig. And we were able to explain how multi-sig works to them. And they said, holy crap, we did not know about this. And they changed it. So hopefully soon we'll see the bill come out of Washington State and it will exclude things like multi-sig. But that doesn't scale, right? Going state by state for us does not scale. And number two, even if we get all the states to kind of follow our thinking, they're going to be still very different laws. And so if you are going to have to get licensed, it's going to be completely different, very expensive for you to do. So ideally, we want some uniformity. So again, this is where I mentioned before, we've been working with the Uniform Law Commission, which is, as the name sounds, it's a commission that creates uniform laws. And they create model acts. These are mostly academics that form committees that propose uniform laws that states then will adopt into law. And so the ULC is presently working on, let me see if I get this right, Peter, a Virtual Currency Business Regulatory Act.
Uniform Regulation of Virtual Currency Businesses Act.
And this will be probably completed next year, and after that the states will have to look into it. The good news is that they have adopted our definition. And so we're very optimistic with that. And it's great because we can, when we're talking to individual states, we can point to the ULC's draft and say, look, this is how they're doing it. They're using our definition. And that's very persuasive. But that still doesn't scale because even if it passes and the ULC adopts that act, states are still going to have to, one by one, adopt it.
Yeah, the
There's no guarantee that they will all adopt it. And number two, even if they adopt it, they might adopt it with tweaks.
Yeah, the ULC's Uniform Commercial Code, which governs merchant contracts and tries to make merchant contract law the same in all the states, has been adopted by all the states. But other uniform acts that they've promulgated, like the Uniform Money Transmission Act, have only been adopted by, say, 7 states. So that would not, that would not gain us too much here.
So what would we want ideally? Ideally, what we want is federal preemption, right? We want the federal government to say, this is crazy. You can't have, innovative startups have to go get a license in 50 states. Let's just get rid of that and just have you come get, go to one place and get one license, either from the federal level or create passporting like they have in the EU. You get it in one state, it's good in every other state. That would be ideal, but that would require Congress to pass a law, right? That creates an act of Congress that preempts, that takes power away from 50 state regulators. It gets rid of 50 regulatory agencies in the states. That is politically infeasible. That's not going to happen. Number one, nothing's getting out of Congress these days, and certainly not anything that's going to take power away from 50 different state regulators. So that's not really an avenue for us. But we've been given a gift very recently. There's this agency you've probably never heard of before called the Office of the Comptroller of the Currency. The OCC is an agency of the Treasury Department. It is the agency that charters banks. Federal banks are chartered by the OCC. And they recently put out, about 2 or 3 months ago, they put out a white paper, which you call their Innovation White Paper. And in it, they said, and by the way, they put this out kind of under pressure from a lot of fintech firms, especially marketplace lenders, and some folks in Congress. And they said in this white paper, the US is falling behind in financial innovation relative to the UK and to Singapore. And a lot of the blame for that lies with us. It's like, whoa, you're a government agency, I can't believe you're saying that. And they say, we as an agency are very conservative and we are resistant to innovations, and we do not charter innovative companies. And we want to change that. And they had, we have some ideas. They want to create a central office of innovation at the OCC, which is like, okay, great idea. But we also would like to take comment. And they had like an open comment period where you could submit what your ideas were, and that led to a workshop. And one of the things that we proposed, and others proposed, Circle, for example, also went with us on this, was we proposed a limited purpose fintech charter. Okay? So what does this mean? Again, this is the agency that charters banks. Banking has 3 functions traditionally, right? Deposit taking, lending, and check paying. And check paying is what we now know as access to the payment system, right? We're saying create a very limited purpose charter that does not do deposit taking. We don't want to take deposits of dollars. We don't want to take deposits. We don't want to do any lending. We just want check payment, access to the payment system. So if you're an exchange, I can ACH you dollars, and you can give me Bitcoin to my Bitcoin address. Right? It solves a lot of the issues that a lot of startups have with access to banking. But more importantly, if you're able to get this charter, you're a federally chartered bank now, or a federally chartered institution. You don't have to worry about getting 50 state licenses. Preempted. So you're good to go there. And the good news is that the OCC has been very receptive to this. Very recently, the comptroller of the currency, who's the head of the OCC, gave a speech in which he, won't bore you, but said some technical things that lead us to believe they will be doing this. So cross your fingers. It helps a lot that the marketplace lenders, the peer-to-peer lenders, have asked also for a fintech charter, for a national fintech charter, but they're asking for one that has access to the payment system plus lending. So what they're asking for is more. We're asking for a very limited, humble thing. So at the end of the day, whatever we get, whenever the OCC gives us something, I think we'll get what we are asking for. But now notice this. This solves the 50-state problem for the folks who will absolutely be regulated, right? So if you're going to be custodial, rather than going to 50 individual states, you can now go to the OCC and get one license. All these other folks who should never be regulated doesn't do anything for them because they're still under the shadow of the state money transmission law. And you don't know if you're creating a multi-sig wallet service if your state or the state in which you have customers is going to find that you're a money transmitter or not. So what do we do about that? So for that, we've proposed a federal safe harbor for non-custodial uses of cryptocurrencies. And that would be an act of Congress. We would have to have a law, but notice this is a much more limited law. And it would preempt state money transmission, but it wouldn't just get rid of state money transmission. We would tell the states, hey, what you guys are doing with state licensing is very important to protect consumers, but we're going to preempt you in a very limited way. Congress would say, great job, guys, but there is this class of activities that poses no risk to consumers, and a state, you as a state, may not require a license or otherwise permission activities that are non-custodial in nature, period. And that would solve that. So that's what we're working on. Recently, we announced the formation of the Congressional Blockchain Caucus, which is essentially a caucus in Congress where members of Congress who are interested in this can begin to come together and support initiatives like this. And we hope to have legislation that creates a federal safe harbor for non-custodial uses of cryptocurrency soon. Probably not this Congress, because it's over very soon, but certainly in the next Congress starting in January. So that's what we're doing there. And next, questions?
Have you considered pairing with EFF so that, community participants can pressure our senators and House reps? Okay.
So we have a good working relationship with EFF and working with them, for example, in the most recent draft of AB 1326 here in California on that issue.
But actively to get them,
Here's the deal. So EFF is great when it's time to kill something because it's coming and it's bad. Right now, what we need is to work closely with Congress to develop the bill, get it introduced, and if at some point it looks like it might not pass, we definitely need to activate EFF to do that. But we're in close contact with EFF and their good friends. So anyhow, so that's money transmission. I'll take any other questions, but then Peter's going to talk about securities law. Yeah.
Does this ever include an endeavor to reduce or eliminate the use of blockchain as an unaffordable noun?
So that is a big issue. I mean, it's hilarious, but until you have to deal with this every day, when you walk into a member of Congress's office, and they talk about blockchain, and they talk about blockchain for Veterans Affairs. I'm not kidding. So there's what's that?
Private,
Well,
permission,
so
closed.
There's two things, right? So one is, for us, there are very few policy issues related to closed blockchains. It's a database, okay? I mean, let me not, disparage it completely because, look, there are a lot of reasons why you might want to use a private blockchain. It might give you some efficiencies. But there are very few policy questions there because it's not an open network, right, that disintermediates people.
And you have a closed group that is there and ready to lobby for their own thing. Right.
And probably their own contractual relationships.
But that said, a lot of folks in Congress, they don't know the distinction. That's a lot of what we're doing. So we'll soon actually have a paper about why open is critical, why you can't, like how there are certain use cases that must have open networks. Question back there.
So with this OCC charter, would it be something that institutions or entities that are utilizing, for example, trusted setup, like Zcash, would they be required to utilize one of these methodologies, or a group of people looking to get an issuance requirement? Because in the event of a trusted setup
Failing, there's consumer risk. The kinds of consumer risks that banking laws and that money transmission laws deal with are a little old-fashioned. I'm holding a bag with other people's money in it, and I could either run away with that bag or it could get taken out of my hand. Now, I know there's sort of a metaphorical equivalence here, wherein if the bag had these holes designed into it because the trusted setup was done poorly, and then the money falls out of the bag, and then people pick it up. This is a silly metaphor, but I think you see my point. And you have to understand that the priorities of regulators here is to look for the intermediary who's a normal going concern, a normal business, not someone building a technology from the ground up or a network from the ground up, but something like a Coinbase. That's very easy to understand. And to make sure that in those situations, where we have definitely seen massive failures as well in the way of Mt. Gox or in the way of Bitfinex, that there are some sort of consumer protection regime in place. So I appreciate the question, but it's a big leap, I think, for policymakers to come to understand the kind of threat that you're explaining.
I think you're giving too much credit to regulators
Okay.
in the following sense, because regulators, because they have only lived in a world with intermediaries, that's what they're focused on.
And that's what all these
Focus
laws,
on intermediaries.
yeah, and that's what all these laws are actually drafted to reach as well. So you would actually, yeah.
So question here?
Yeah, so I've kind of experienced payments regulation as a practitioner. And frankly, while I would have welcomed an OCC FinTech charter, I don't think it would have solved my real core problem, right? Because in the payments industry, big banks bank with the Federal Reserve and have direct access to NACHA and Fedwire, but little banks don't. Little banks bank with big banks that bank with the Federal Reserve. So given that little banks have to bank with big banks that bank with the Federal Reserve, being a bank wouldn't fix my problem. So how does this make it easier for big banks to bank fintech companies?
Well, what you would really want, ideally, and this might be too big of a reach, but what you would really want would be a federal charter, limited purpose, that grants access to ACH, Fedwire, NACHA, and does that in some way in conjunction with the Fed, because that's the regulator on point for those payment rails.
Do you think that politically the banks or even the FDIC would be prepared to tolerate that?
You wouldn't have to be FDIC insured, and that's part of what Curry was talking about last week. Not to bore you guys, but they've begun a rulemaking to revive receivership for non-insured federal institutions.
Which apparently there are about 10 of or something from back before the FDIC even existed, but the OCC did.
But I think we're getting to the
Yeah,
weeds.
let's talk
Lose
about this
everybody
offline,
else.
Scotch.
Okay. So,
Can you put the microphone closer to your
Sure.
mouth? Because I lost most of that last comment. I think it was quite a subtle joke.
well, all I said was, I don't want to lose anybody, so let's move on to the next thing. Okay. Okay, so if there are no more questions, I'm going to turn to Peter, who's going to talk about securities.
So we started looking at this about a year and a half ago, primarily because of Josh Garza and Paycoin. So Josh Garza, for those of you who don't know, is sort of a serial scam artist. He started Geniuses at Work, which was a cloud mining company with no actual mining hardware. Before that, a lot of people don't know this, he actually defrauded the state of Massachusetts by promising to build high-speed internet access upstate, getting a grant for it, and then just not doing it, which is a nice, simple scam, actually. So the SEC at the time was starting to look into the cloud mining scam, Geniuses at Work, and inevitably we believed, and we were right, they would turn to the Paycoin scam, which meant that the question of whether selling these tokens, these Paycoins, was a security would rise. And what we wanted to do was to create a framework that would give the SEC the tools to make a distinction between why Paycoin is a security when it was sold the way Josh Garza sold it, but Bitcoin or Ethereum or read a certain number of other things may not be securities, so that they don't make a blanket judgment that would mean that core devs all over the world need to register as securities issuers or promoters and God knows who else. So why security laws and tokens or cryptocurrency? They're heavy-duty regulation. They're seek permission, not forgiveness type regulation. Crowd sales and pre-sales may subject the developers to securities regulation. There have been a lot of scams, Paycoin being the most evident. A lot of vocal pundits in this space, many of them unfortunately from the closed blockchain arena, have taken to public platforms to say that basically all of these sales, maybe with Bitcoin accepted because it was so early, but maybe not, would qualify as unregistered securities issuance. Why US security laws specifically? There was the global question earlier. Well, that's because if you have any US purchasers, no matter where your company is based, you will probably be subject to US laws unless you're perhaps in a country that doesn't have extradition. But that's a slim and shortening list. US securities laws are the most broadly applied than other jurisdictions. In other jurisdictions, the set of activities that are securities is usually an enumerated set, and the regulator is given a power to add things to that list. In the US, it is not a set defined by the regulator. It is defined by a federal court judicial test. So basically, the term investment contract is not defined in the securities laws, and there are federal court tests to figure out what things are investment contracts and what aren't. So the SEC basically has a fairly unbounded jurisdiction here to go after any number of scam or scam-like things or things that look like securities. And the federal courts will, after that initial investigation and charge, either claw back that out of their jurisdiction by saying that didn't fit our test or say, yes, that did fit our test. The Securities Exchange Commission is already investigating Paycoin, and the Dow did get the attention of some of their staff.
Sorry, what does that mean, got the attention?
Yeah, so they're not, there is no, at the moment,
We don't know
public
that there's
investigation,
but
but they are aware of these happenings and have a decent understanding of basically the underlying fundamentals.
Conversant.
Yeah.
It would be useful to clarify that Bitcoin is not a security.
That's exactly what our framework seeks to do.
I know you agree with it, and I know it's not necessary because maybe some regulators think that it is.
look, that's the whole point of what we're doing.
There is no way.
Yes.
Anybody on their right mind who has a simple book of monetary economics that will define Bitcoin as a security. No matter who sells it, no matter.
I think that's right, but courts, federal courts can be strange beasts, and so that's why we're trying to create a legal framework.
Florida from that lady and probably governments that said that Bitcoin is not money.
Yeah.
And another decision in New York State that said Bitcoin is money. Anyway, if it comes down to the time, people probably haven't studied the subject, that's what we're going to get. But for the community, we need to clarify
Yes.
that Bitcoin is not a security, and that the price fluctuation reflects
Yep.
the growing quantity of the other currencies. Because Bitcoin is going to be faster than money.
Yeah.
All the fluctuations that people see and they can analysis to get excited.
Well, I mean, it doesn't even have to have anything to do with the other currencies. You can just say that the price of gold fluctuates wildly, and it does, and that it's not a security. So that's the framework that we've developed, is a framework that, yes, that uses a legal test that is on point here to speak to the SEC and to other people in this space in the language they understand and help them understand why some things are not a good fit, even if things like Paycoin are a good fit. So I sort of covered this. I'm not going to go through too much other than the fact that the courts have a very broad-reaching test, and it's deliberately there to reach the countless and variable schemes devised by those who seek the use of the money of others with the promise of profits. That language comes from the Howey case, SEC versus W.J. Howey, from which we get the Howey test for a security, which is the test that's on point for judging any investment offering as a security or not as a security.
So would that mean if, for example, let's say Bitcoin and Ether were money, in the case that you were posting or instantiating that into a contract where the use of that money was for return of future profits to people who invested it, then that would be a security?
Yeah, so even without a token necessarily, a naked smart contract address that does some sort of pooling and does some sort of return on the pooling, that could qualify under the
So
test.
from your perspective, would the Dow fall in that context?
The Dow very much looks like a security under the Howey test. It's up to a federal judge to ultimately say that, if it ever comes to that. Yeah. So to understand,
We're lawyers, we're going to have qualifications for everything we say.
We had great conversations about that, and just from the perspective of a community member, and from my perspective, I just want to know where you stand with regards to the specifics.
yeah, to the specifics of the Dow.
Yes.
I just answered it. He said the same, thank you.
You already
Oh, yeah. Oh, sure. So to understand exactly why the test is an issue, it's important to actually look at the facts of the Howey case, because they're actually kind of fun and they make it easy to understand. So the Howey case, like a lot of strange and bewildering stories, starts in Florida, where a guy named W.J. Howey had an orange grove and a hotel, and he'd invite rich New Englanders to come down to his hotel, and he'd give them a tour of the orange groves, and the New Englander would say something like, "Oh, the oranges are so beautiful," and then W.J. Howey would come up and say, "It's a funny thing you should say that. The orange groves are for sale." And basically what Howey was doing was partitioning his many-acre orange grove into little tiny tracts of land, like an acre or 2 acres, and selling them to the people who stayed at his hotel. They would get the deed to a piece of land with orange trees on it, but they would also be heavily pressured to sign a contract where W.J. Howey would be made the person who would have the obligation of maintaining the trees, picking the fruit, taking the fruit to market, selling it, and giving you the fair share of your land's orange profits. Now, what's important to note here is at no point did W.J. Howe say, here's your stock certificate, here's your share in the going concern that is the W.J. Howe Orange Grove. Howe just said, I sell land and I pick fruit. That's all I do. But the Orange Grove turned out to be not so profitable after all, and there was a lawsuit. And the lawsuit went all the way up to the Supreme Court because the SEC very much wanted to make the point that this, despite being seemingly a real estate deal with a maintenance contract, is in fact a security. And they gave us the Howey test in order to reach that conclusion. And it's got 4 prongs. It's an investment of money in a common enterprise where the investor is led to expect profits solely from the efforts of a third party or promoter. And again, it says formal certificates are not necessarily required. All that is necessary potentially is nominal interests in the physical assets employed in the enterprise. So since then, several different strange sales of nominal assets have been classified as securities, everything from chinchillas, marmots, Preston Byrne would be very, very upset, golf course memberships, gold bullion, weasels, all kinds of things. And perhaps now that the SEC is looking at this carefully, perhaps the sale of pay coins, because basically what was sold was a nominal interest in a physical-ish asset. It's virtual, but you know, the analogy with gold or the analogy with any kind of commodity money makes a lot of sense in any cryptocurrency, even potentially a lousy one. And so to work through here, what we're talking about, instead of selling people land with orange trees on it, Josh Garza was selling people pay coins. Josh Garza made a number of warranties or promises. He promised that there was going to be upcoming Amazon integration. It's great that we have a curse here, actually. Yeah. He promised that there was going to be very soon Amazon integration, a minimum $20 price floor that they would always guarantee by promising to repurchase pay coins in the future for $20. It was going to be the future of money, things we've heard many times. They made a lot of profit in their pre-sale, walked away with the Bitcoins, stopped developing the thing. They never developed it to begin with. It was a fork of Peercoin that they changed a couple of lines of code on. And people were left holding the bag, basically. And so it's very similar to basically a non-profitable orange grove that you got transferred the nominal interests to some of the land in. So recognizing that the SEC was already looking at the Paycoin situation, and this was still a full year before the Dow, we created our framework for securities regulation of cryptocurrencies. We originally presented the meat of the framework in a PowerPoint presentation that went for about an hour in front of probably about 100 staff at the SEC, and branch locations phoned in. And then eventually we issued a report. And basically, if you're really interested in this topic, I'd advise you to take a look at the reports available on our website, coincenter.org. And you can actually skip the first 2 sections, which try to go into some detail explaining how different variables in the technology and the community, how they look. So how decentralized is the development effort? Is the source code for this so-called offering open? Has the thing been built yet? The different practices in the community, the different possible variables in the technology. You can skip those sections and go straight to the legal conclusions, which should be familiar to you, where we map some particular quality that the cryptocurrency on offer has to the relevant prong in the Howey test that would either make it fit the Howey test or not fit the Howey test. So basically, we conclude that there are certain things that are likely to qualify as securities, and these are closed source or low transparency cryptocurrencies. So OneCoin, anybody familiar with OneCoin? Well, I mean, OneCoin's not even a cryptocurrency because we don't see a blockchain, we don't see any source code for a client, we don't know anything about it.
But it's audited.
It's fully audited by a very skilled lady who's got a PhD in something, I guess, I don't know. So if you can't see the source code, if it's not really a running network with an open blockchain, you can assume that it's probably going to fit the definition of a security. If it's an open, so open source and open blockchain, but heavily marketed pre-sale or sale of pre-mined cryptocurrencies that has a small and non-diverse developer community, this is Paycoin. You know, I mean, Paycoin was open source for all its faults. You could actually look at the client, as terrible as it was. And finally, cryptocurrencies with permissioned ledgers or highly centralized community of transaction validators. This one makes sense simply because basically we rely on the identified community of transaction validators in any sort of consortium or closed chain. If they do have a token traveling on that chain, so for example, R3's Quarter doesn't even have a token, so it wouldn't matter. But if there is a token traveling on that chain, then in a certain sense, that token may qualify as some sort of a security.
Like Stellar or Ripple.
Well, so we actually go into detail about consensus mechanisms in the paper. We explain the difference between proof of work, proof of stake, at least as it's envisioned, and social consensus, where social consensus mechanisms, we say, don't really necessarily qualify here because you don't trust an enumerated set of participants. You trust the number of people that you need to make a trusted link with the person you're paying. So social consensus mechanism is what we refer to it as. So I would argue that it's harder to make the case that Ripple or Stellar actually fit easily into the definition of securities because you're still working with a distributed network that's effectively open.
What about Ether?
So
For the second.
for the second, so Ether's pre-sale is alarming. And you have to ask yourself, how diverse is the development and the mining community in Ether?
One pool.
Yep.
So 47%.
Another option here that would potentially be an avenue would be to classify the Ether pre-sale token as a security because it was used as a speculative investment to finance finance development of the code base rather, and then to classify Ether, the token that people ended up getting in reward for their contribution to the pre-sale, as not a security.
So is it about is the difference then the expectation of work to be done with the investment money that goes into the...
There's a lot of that in the test. The test is fuzzy, so I know as really smart developers, you want probably more mathematical explanations for these things, and unfortunately that's not how common law works. It's this organic system. Although it's probably not unlike Bitcoin Core, considering what we just learned about it. But there's a line of cases that deals with golf courses and country clubs. And in these cases, if the golf course or country club had not been built yet, but the developers solicited people to give money for memberships, those were classified as securities. But in cases where the golf course or country club was already built and they were simply selling memberships, even transferable memberships, those were not deemed to be securities.
What was in that case law, were there definitions or differences amongst what built then? Like if the course is nearing completion? Like
These would be things that a lawyer who is trying to make the point about my token wasn't a pre-sale, so it's saved from this, would definitely want to look into. It's still going to be metaphorical because a golf course is not a distributed computing platform, but it's certainly the right metaphor, I think, ultimately.
But given the number of appcoins and altcoins that are going through these processes of pre-selling and really doing,
Yep.
We're not seeing any action at all
No.
from regulators. Are they really just saying the amount of money isn't big enough, so we don't care? I mean,
Yeah, so we're lucky in the sense that while they're aware of these things, so this is one of the things sometimes people say, why are you bringing this up? Don't bring this up, you're gonna poke the bear and it's gonna come over. They're aware of these things, and as I said, there's plenty of people who are poking them saying, all of these things are securities, you should just go now. So while they're aware of these things, they're resource constrained. They need to use their regulatory resources to go after the true bad actors who are both obviously at fault. So maybe like a Paycoin case would be a good test case, whereas a DAO case would be more difficult because it all went wrong in most part because of a hack, not because somebody took people's money and, well, unless the Socket guys are the hackers too, which maybe is, I don't know, I mean, it could be. But basically the DAO is very complicated. We know with Paycoin there was just basically this one bad guy back there who was pushing the whole thing. So a clear bad actor would be a better test case than going after many or all of the many more complex questions. And then also maybe they don't want to say anything on this matter for a while because, as you said, it's in general fairly small potatoes compared to the international securities fraud.
How long do they have to come back in time and go after you?
Yeah, the statute of limitations is 3 years. 3 years.
So not long.
Not long, and this also actually, well,
For Ether, it would
So Dogecoin
Yeah.
themselves.
Dogecoin might be out of the woods.
Yeah. So is Litecoin. In fact.
So for example, one coin meets 1 and 3 of your criteria.
One coin's
Yeah.
totally.
I mean, yeah, if they even have a ledger. Maybe they don't meet 3, because who knows what they have. They have a little book. That's a ledger.
So what about,
It's gonna let us know, right?
what about Steam, right? So almost all the development's been done by this one company. And a small and non-diverse mining community, in addition to small
Staking.
and non-diverse developer community. Who knows whether that
No
one month
pre-sale.
proof of work counted as pre-mined? It's unclear whether that 1 month proof of work counted as pre-mined. But given that Steam Incorporated mined 80% of it, probably.
I mean, pre-mine and pre-sale are different, though. So I think pre-sale's the really ugly one, because that's the one that looks a lot like we were raising money to build a golf course, and we hadn't built it yet when we were selling memberships.
Okay, but like pump and dump might be the same thing, right? Because they've been selling it as they're vesting out on the public markets, and they keep pushing the price down. And it's a highly centralized community transaction validators. There are 19 of them, and they're all fully identified.
Well, but there's also one. There's also one who's proof of work.
Yeah. That's right. There's a token proof of work.
Token. Token. I mean, these are all open questions.
Yeah, we're not going to, there's no way to know these,
Yeah.
the answers to these questions until the court decides them.
And
All we can do is give you.
And honestly, as was said earlier by the gentleman over there, the most important thing in general is to especially save the long-standing projects like Bitcoin from ever being classified as securities.
And it's been over 3 years for Bitcoin since Satoshi's out of the woods.
Right.
So are there any people that are kind of playing on the other side of the fence? Because, I can argue, something should be, think Jobs Act Title III.
Yeah.
Huge costs of doing all the transparency and all this kind of stuff.
And then you can't even raise that much money.
And you can't raise that much money. Are there people that are sort of on the other side of the curve and saying, we want it to be a security for any, you know what I'm saying?
The funding companies.
Yeah, well, there is a middle ground. So I love Zuko. I think he's awesome. And the approach that Zuko's taken with Zcash is, I think, incredibly reasonable, incredibly cautious, deserves a lot of respect. He did a private raise, just as anyone can do a private raise of funds to develop software. And he only did it from accredited investors in the US, which means you don't actually enter into the realm of securities regulation. Then once the platform was built, well, in theory, sometime around this October, I think, we'll have Zcash, which will be a token, but the platform's already built.
So you can do a pre-sale as long as you only sell to accredited investors.
If you think of the private raise as a pre-sale, and from what I understand, some of the people involved in the private raise may be paid back with Zcash as opposed to.
Could somebody do a Jobs Act Title III, meet those criteria to give out tokens? I don't know.
Conceivably, but the biggest problem with the Jobs Act is the limitations on how much you can raise. So it's really best suited for something like building a restaurant in a local community where you want local people to have some stake in the.
There are also heavy auditing requirements that you wouldn't have.
So you're going to still need a big compliance team, which is, and very expensive lawyers.
Sort of the blockchain might be a bit cheaper. And Marco Santori.
Marco Santori.
For good times. Centauri times.
So that's likely to qualify as a security. Here are a list of things that do not easily qualify as security under the test. And so here we have highly decentralized cryptocurrencies because of a lack of vertical commonality, which is a technical term, but basically we don't, as I said earlier, I think we don't treat gold bullion as a share of the gold industry. It's a big decentralized community of people who are mining gold out of the ground, who are finding uses for it in jewelry or in industry. And yes, the value of my bullion is dependent on all those people, but I can't be said to rely on any one of them.
So on your last point.
Yes.
Can we maybe this? Oh, sorry.
Sure. I'll move quickly then. Sidechained cryptocurrencies or proof of burn cryptocurrencies, because it's difficult to make the case that there was an investment of money if there's a one-to-one peg and you can always get out. It's difficult to make the case if there's an investment of money when you're provably destroying money rather than handing it to someone else in order to get some kind of return on your investment. So counterparty, relatively safe. Cryptocurrencies where the initial distribution is made through open competitive mining. I mentioned proof of burn, again, because there's no investment of money. Appcoins or distributed computing platforms, potentially Ethereum, because the participants seek access to these tokens for their use value rather than an expectation of profits. Now, I see you, you're squirming, you're squirming. The case law here, yeah, so how do you judge? It's always how do you judge, but the case law here comes actually from condominiums and co-ops. So in New York City, a lot of people don't buy an apartment, they buy a share of 240 East 35th Street, where I used to live. And they get an apartment out of that deal. Now, you bought a share in a corporation, basically. But the courts have roundly said that basically sales of these co-ops or condominiums do not qualify as issuance of securities. And the reason for that has been given in the case law is that though they may have some sort of speculative value, though you may buy an apartment in New York expecting it to go up in price, you also buy it to use it, to live in it, to get utility out of it.
You want an apartment.
Yeah.
It's much easier to sell a crypto token than it is to sell a bond.
I think that's true, but liquidity doesn't actually enter into the court's reasoning there, so that would be a new distinction.
So taking this use case problem.
You said value, and you meant the price in dollars. So when you make a distinction
The price in dollars?
of the condo or the token or whatever, we think in dollars, right? Price goes up, so people make an investment.
That's a good point.
But the value is something else that has a broader.
Yeah, although if there are open exchanges for these things into any various fiat currency, yeah.
Kind of have the conversation that the price in dollars, people are used to everything going up. That's why they invest in real estate or gold or whatever. Now, the value of gold recedes.
I think people invest in Bitcoin because they expect the price in dollars to go up as well.
Absolutely.
Yeah.
And there's nothing wrong with that. But the value, because somebody may say, there's people asking for that, there were people claiming that the CFTC has to come in, and when Bitcoin, the Bitcoin price goes too high or too low, they should stop the trading. So I've heard that too. So the value of Bitcoin per se is not its price in dollars.
So from the use value issue, so what is the timing on that? So, for example, you take a company like Scenario, which built a project around building a social network.
Yeah.
They released a token called an AMP, which funded the development of the platform. The timing before there is any use value for the AMP is significantly later
Yep.
than when it's released. They can make a case that it's use value people are buying for future use value, but until that's realized.
So that's where the golf course cases come in.
Yeah.
Because a membership in a golf course is a use value for rich people who want to do that kind of thing, I guess. But if you're pre-selling these memberships to a course that hasn't been built yet, could maybe not be built or built really ugly or something. I don't know what makes a golf course bad.
Right.
It's probably any number of things. If Trump built it, maybe. Then that's where that case law comes in.
So you said the liquidity doesn't necessarily matter. What about the liquidity prior to a use value? So in the event of, is there a case law where the expectation of the speculative increase in land value was the reason why you would buy the apartment, not for the apartment, and as such became a security before it became a use value?
Like New York condos that are empty because of Russian.
Yeah, yes, or building a shitty apartment complex on a plot of land just to have something on the land because the city's going to seize the land.
So the case law that I've read, and I haven't read all federal court case law, but the case law I've read doesn't make any such distinctions. And I think that may be part of the reason why you do see a lot of questionable real estate deals in apartments that stay empty for years. That and probably money laundering, which is probably much more vibrant in the real estate community than in Bitcoin even. But that's how the law works. So you're balancing, evils. We can't have perfect enforcement of the laws and prevent all the scams, because if we did that, we'd stifle so many legitimate things, like people who actually buy to own a house. I think, I think we'll see the same problems emerge in decentralized governance systems as well. Yeah.
Yes, I don't want to crypto for
Josh.
Terrified or excited are you about
question these things reaching the Supreme Court at some point in the future? Is that, I mean, do you think that's?
Or any court, frankly, because
Well,
for us to
we'll be
reach.
excited when Peter Thiel's on the Supreme Court, right?
Well, I mean, Bitcoin's making it work. It's getting there along all these metrics. So it's only natural to expect that there will be cases that.
Oh. Yeah, I think it is natural to expect them. The question is whether I'm excited or I think I'm not particularly relishing it because it means that somebody's been dragged into court. Now, maybe if it's Josh Garza of Paycoin, who I'm personally quite convinced is a scam artist, and I don't think that's like a really nasty value judgment on my part, maybe it would be okay, although then the liability there is that the federal judge could get it wrong and leave a precedent that would hurt everybody in the space long term. And that's the rationale for us developing this framework, so we can have an anchoring bias, set expectations as to how these different prongs of the Howey test can be interpreted in light of the actual technological fundamentals and community variables.
So, risk management question. How likely do you think that they're going to bring a cryptocurrency as a security case before a court sometime in the next 3 years?
Likely.
Likely?
I mean, unless they settle, right? Because Josh Garza's probably going to settle out of court.
Yeah.
I mean, that's the
And
thing.
settlements is count as precedent, right?
No, so actually taking that into consideration, maybe not.
Maybe not, maybe just settlement.
Settlements, yeah. We'll see enforcement for sure.
God, I love short windows there.
Is this the end of your presentation, or is there?
Yeah, I think that's it.
Yeah, there's some key findings here that are mostly relevant to building stuff on top of Ethereum. This is taken from a presentation I gave in Shanghai last week. We don't have to go into them. This is some common sense stuff that especially the Ethereum community needs to listen to. Just never use the phrase initial coin offering. And non-ironically. I mean, some of it's ironically, but don't use words like profit sharing, because and there are others, but these are two big ones. These are the bread and butter of securities. And why would you poke the bear? I mean, I don't care if you're located in Somalia or wherever you think you're located. Endorsing.
There was a comparison of Economy that just is in the process of doing ICO, and their text was matched up against the SEC's text for Ponzi scheme. And you look at the two and you're like, okay,
why?
Said this.
And yet people still buy them.
Yeah.
The other thing that we want to really avoid is endorsing risky ventures or claiming the endorsement of other people. So you all know that I'm probably talking about the Dow here, but I'm talking about anything. So you want to endorse somebody else's project, you should think about whether you might be classified as a promoter of that person's security, because you might be. And if you want to claim that somebody else in the community has endorsed your project by, say, putting their picture up on your website, you better be a mensch and talk to them about it and have a conversation about their regulatory risk appetite, and then see if they still want their face on your page.
From a perspective of, let's imagine it works, would proof of stake fall into that profit sharing perspective?
So profit sharing we just use as sort of like a rhetoric that should be avoided. That's not a determination, that's not determinative. To go back to the original slide on the Howey test, formalities like the use of the word share or stock or certificate or profit sharing don't matter. What matters is the function and the substance of the arrangement. And a proof of stake, so if there's an open competitive market for the coin, then you can buy in and become a stakeholder. So that's what would make me argue that this is more of a decentralized enterprise. Could be, if it truly is, more of a decentralized enterprise rather than a situation where you have identified consortium members validating transactions or something like that.
So it's been about an hour. I'm going to put it in one last question.
I was going to say, so you guys have done advocacy for other industries. In terms of the work you're doing now for this industry, is there anything missing and that would help you do your job better, that either the community could provide or think tanks? What else do you think you need? Because obviously the volume and the heat of your activity is going to be increasing.
Peter, do you have our QR code up?
So less cool.
Yeah. You do actually kind of obliquely raise an interesting thing. We don't represent the industry, and we don't represent companies. We're not a trade association. trade associations typically are like the Internet Association. The Internet Association has members that are usually corporations that become members of the association and then direct that association for their interests, which is awesome. And the Internet Association is a great association that we tend to usually agree with. But then you have things like EFF. EFF is an independent nonprofit that sets its own agenda. And Coin Center is on that model. We're an independent organization, and individuals or companies are welcome to support our agenda or not, and that's fine. And so what you can do to support us is, number one, support us. Go to our website and make a donation. Get your company, talk to your CEO and say you really should be contributing to Coin Center. Get in touch with us. You'll get a cool Coin Center branded Bitcoin node as a thanks. The other thing you can do is be available to us as devs who are building this stuff when we need to explain this stuff. And so as I said, a lot of the explainers that we have on our website that explain in plain English to regulators and policymakers is Bitcoin Anonymous. What is the Lightning Network? How does mining work? All of these are written by people like you. We can't write all of them ourselves. And when we go to Sacramento to explain multi-sig, we bring developers with us.
Mike Belshie, who ripped a $100 bill in half in front of a number of assemblymen, actually in Sacramento.
So being available to us. So
Did you know he invented multi-sig? That's his trade secret. I have letters saying that.
anyhow, so that's how you can support us. Is support us financially, but more importantly, follow what we're doing and be available to us, and hopefully we know a lot of you. Yeah.
The best platforms to make sure we do follow along with you guys, and is there a massive bifurcation between regulators
Yep.
and the rest of the world?
The best way to follow us
Yeah.
is go to our website, keep abreast of that, subscribe to our newsletter, follow us on Twitter. Those are really the best ways. If you become a top supporter of Coin Center, we communicate more frequently directly with our top supporters.
Although also, if you're just somebody who has a question,
you can
always email us if you have a specific area that you're interested in. We can't really give you legal advice, but we can help you understand the landscape.
Do you guys use the Bitcoin Core Slack or?
I'm on there as Jerry Brito. I'm on I'm on Open Bazaar, I'm on Blockstack, I'm on a bunch of them.
So many Slacks now.
Twitter,
that I check all of them.
email. Yeah. All right, thank you guys.
Thank you so much.
Thank you.